I'm Vinny Politan. Thanks so much for joining us tonight. We've got news in the case involving the so-called doomsday couple, Lori Vallow and her husband, Chad. As you know, they have been accused and are facing a trial that should happen this summer involving what happened to Lori's children who were found dead and buried in Chad's backyard. But Lori Vallow, her husband, Chad, is not her first husband and not the only man that's in her life that's got some issues and has had some problems. All right, Chad Daybell, husband number 5, is in jail. Charles Vallow, husband number 4, was shot and killed by her brother, Alex Cox, who died on the toilet last December. Okay, so he's dead. Her brother's dead. Her 4th husband's dead. Her 5th husband's in jail, waiting for trial related to her dead children. Meanwhile, husband number 3, Joseph Ryan, also dead. But the question is, was there any sort of criminality associated with his death? Apparently not. Let's bring in Court TV legal correspondent Chanley Painter and Court TV anchor Ted Rowlands to break this down. So, Chanley, the final word on the death of Lori Vallow's husband number 3, Joseph Ryan, is?
He died of natural causes, Vinny. Now remember, this was reopened. The Phoenix Police Department reopened a review into Joseph Ryan's death in 2018 after a recording of Lori Vallow came to light. Remember the recording from October 2018 where Lori tells a group of people that she wanted to murder her 3rd husband, Joseph Ryan? Well, upon receiving that new information, they went back to review Joseph Ryan's death. He passed away of an apparent heart attack, according to the police report, in 2018. So they reopened that, they reviewed it, and today we're learning that they've closed the case. No criminality here. It was a natural death.
Ted Rowlands, husband number 4 was shot and killed by her brother, Alex Cox. Husband number 3, I think, was tased or something by Alex Cox in his middle area, as it was described, I believe, by Alex Cox. So there was some history here. So there was a reason to investigate his death.
Oh, absolutely. And then when, once the case started to unravel and the details came out with the missing children and the dead children, investigators obviously said, whoa, wait a minute, let's go back and look. And they have concluded, I don't believe it, that they had nothing to do with the Joseph Ryan's death. Now, I do believe it. You take them at their word, but it absolutely made sense to go look at it. It also does factor into the story. She has a dead spouse. She's been through that. Life insurance issues, it does play in somehow, I believe, in the narrative of how they got to this disgusting end. But now we know that they didn't, and Alex Cox didn't apparently kill Joseph Ryan.
All right, so as we sit here tonight, there are 3 people in the sphere of Lori Vallow Daybell who have all died of natural causes at relatively young ages. Her brother, Alex Cox, on the toilet, Joseph Ryan of an apparent heart attack, and husband number 5's wife, Tammy Daybell. That's still natural causes so far. We'll see if that develops into anything. Let's get to more news now, Chanley. I want to put this up on the screen because Mark Means, the attorney for Lori Vallow Daybell, has an issue with apparently trying to communicate with his client. He's now requesting for an order directing attorney-client privilege communications. He hereby moves the court for an order directing the Sheriff's Department of Madison County, State of Idaho, and the Madison County Detention Center employees to allow access and privileged communications between attorney Mark Means and client Lori Noreen Vallow Daybell. So, Chanley, to me, this is a legitimate concern, right? This is preparing for a trial, and he wants to talk to his client.
Yeah, and this has been an ongoing concern that Mark Means has raised ever since the spring. So in this motion just filed yesterday, they're saying that this is under the 6th Amendment right to counsel and that the Madison County's Women Detention Center has this ongoing problem of allowing attorney-client privilege communications. Like you said, essential part of preparing for a trial. So in this motion, he goes on and he says that on or about March 30th, 2020 until June 9th, 2020, I was denied access to my client to meet in the attorney-client room of said detention center. I was denied such without notice until my arrival at the detention center on March 30th, 2020. I voiced my objection to Prosecutor Robert Wood and the deputies at the detention center, but was still denied access to said room and my client. I was forced during this time to prepare our case in this matter subject to the unreasonable conditions illustrated in the attached photographs. I was limited to telephonic communication with my client. So get this, Vinny, he attaches photographs that he took at the Women's Detention Center there in Rexburg, Idaho, of what he calls unfair circumstances when he has to go in and meet with Lori Vallow. This is due, of course, to COVID-19 precautions, but he says this isn't right. There's the meeting room, that's the public meeting room there. There's a phone with a metal wire and cameras. He points to cameras, 2 cameras within that room. And remember, he alleges that the detention center recorded at least 2 conversations right there in the blue. That's Lori Vallow. Her face is covered, but that's through the glass of what he would see meeting with her. So they can either meet by telephone, which is within earshot of a deputy, or this way, which is also recorded, but the detention center inadvertently recorded 2 of these conversations. They say they were deleted. Mark Means says no, one inadvertently made it to the prosecutor's office, he said in this motion. That was wrong, and he is now objecting to that. So he goes on and says he went to call the prosecutor about this problem. Prosecutor said, oh, okay, let me get with the detention center. He said they fixed it until January 5th of this year. So let's read on in the motion. It says, on or about January 5th, 2021, in preparation for a motion to disqualify Prosecutor Robert Wood, I traveled to Rexburg, Idaho to meet with defendant. I was again denied access to the defendant with only one option to converse with defendant through the public room with metal corded telephone, again with 2 video cameras videotaping these privileged meetings. So that's where we are right now with this motion, saying it's unfair to prepare for a trial in these conditions, and he wants it changed.
You know, Ted, I'm kind of reading between the lines here in the timeline. Like, you know, Mark Means and John Pryor trying to get the prosecutor kicked off, and then all of a sudden, no more privacy. This is getting kind of nasty.
Well, also it could be COVID numbers were up and the regulations that the jail changed because, you know, prosecutors aren't in contact with jailers at a constant basis. It could have fallen through the cracks that way. But yeah, obviously it looks bad. I mean, the timing looks horrible, like that they're attacking Means. And we already know that there's some discord between the 2, right? The prosecutors basically said Means is a hack. And the bottom line here is they got to clean this up. They got to figure it out. He has to have access to her. This is just setting up an appeal, and there's no reason for it. They have to come up with a solution that everybody's comfortable with.
Yeah. So, Chandler, what exactly does he want? Does he just want the room, a room, and does he feel safe in that room with her? I mean, that's another issue, right? Is always safety when you're in there with a criminal defendant.
Right. He mentions in this motion that every time he goes to the visitation room, his fever is taken. He wears a mask. There's all these other precautions in place, and he does request several things in this motion. He wants to meet face to face with Lori under these precautions in place, and no recording devices at all. No even cameras without audio in there. He wants those turned off. He wants the telephonic system to be turned off because he wants to meet face to face with her. No risk of anything else being recorded. And get this, he also requests, at the expense of the defense, that Lori be handed a cell phone. He wants to give her a cell phone to only communicate with him on this private, secured cell phone line. And of course, he wants to set this matter for a hearing before the judge.
I don't think she's getting a cell phone, Ted. Call me crazy. I mean, it's an interesting request, right?
Yeah.
You know, he wants to get her a burner phone.
Right. She'd be very popular if she's got her cell phone in incarceration there. That people, hey, can I use your phone? Problem is, of course, they'll be calling Mark Means. In this situation with COVID and the rest of it, maybe that is plausible. It sounds ridiculous, but maybe something like that out of the box thinking would work, but something's got to be figured out. So this goes away. This can't be a reoccurring on the record complaint that she can't talk to her attorney.
Yeah, maybe a Dixie cup with 2 Dixie cups and a long piece of string, and we just go old school with this thing. All right, let's get on to the next issue, which are discovery issues, right? This happens in a lot of cases. Prosecutors have information, the defense is entitled to have it, and they want it, and there's problems getting it. Let's take a look at just a taste of what has happened in the past with Chad Daybell's attorney.
Mr. Wood and I have discussed, and I'm not going to make a matter of this, but there's still some housekeeping that needs to be done in terms of discovery that Mr. Wood and I are going to privately engage in trying to resolve, and if necessary, we'll ask the court's assistance. But at this point, without all of the information in this case, I'm not in a position to argue severance on this date, and that's going to have to be reserved for a different date. Allow the argument to be made in terms of severance once Mr. Wood and I have resolved our discovery issues. Once again, and I'm not beating on this, Mr. Wood, please don't take it this way, but once Mr. Wood resolves some of the outstanding issues that we have yet to resolve between the two of us.
All right, Chandler, are they resolving these differences here? Because this is something that, I mean, my father was a judge. He hated being in the middle of these kind of little squabbles. Work it out, guys, work it out. Ladies, come on.
Yeah, Vinny, it's now before the judge. There's been a motion to compel. It's not online yet, but you can see that it's been filed by the defense. That means it's getting serious. They want the judge to interfere and make this happen because this has been an ongoing issue. What we just played there is from months ago at a hearing, and we're seeing motions back and forth in the file of discovery request, and then the state just did a disclosure, which was pretty big. It was a big discovery dump last week, and it included a lot of things, but a lot of them are not online in the file, only went to the defense attorneys. But here's an idea of what was included, Vinny. There's the statements of the defendant and co-defendant, because now that they're joint, they have a right to more discovery as co-defendants. They also had defendant's prior record, documents, and tangible objects, which this was interesting. The prosecutor said, you can make an appointment with my office and come see those tangible objects for discovery. And then also reports of examination and test conducted. The state witness list for the trial was handed over. The expert witness list for the trial was handed over, as well as police reports. So we're hoping that those addendums will be released so we can know exactly who the state intends to call. But that was a lot of information. Again, after a motion to compel, so it seems like that's helping this move along a little bit better for the defense.
Yeah, those motions to compel, I'm telling you, judges just don't like to have to get in the middle of all that. Finally, the state has released the name of their expert when it comes to the big issue in this case, which is change of venue.
Yeah, that's going to be a huge hearing coming up. Not a date set yet on the record, but we know that the state is going to call an expert to rebut the defense's survey of several counties. They conducted a survey of prospective jurors, and now the state has hired its own expert to rebut that. And it's Rhonda Harper, NBA. That is the expert. Ms. Harper is expected to testify with her rebuttal report regarding the unreliability of the defense's anonymous survey memo. So her report was provided to defense counsel, and now this is, again, it's to rebut right there the survey that was presented by the defense and the exhibits there. They conducted a survey of Bonneville, Madison, and Fremont counties that the vast majority of people interviewed by the defense had already made up their minds regarding the guilt of the defendant. So they say that they can't have a prospective juror, a fair and impartial jurors in any of those 3 counties in East Idaho, Vinny, which we have for reference. I think we have a little map that we can show exactly where these counties are. Where Rexburg is in Idaho, which is Madison County, as opposed to Boise, which is on the western side of Idaho. And then Bonneville County would be where Idaho Falls is, which is a little more populated, but they still believe, based on their survey, the defense does, that they still could not find a fair and impartial jury there. So in rebuttal, again, the state saying they're going to call Rhonda Harper. She's an MBA. She's based in Dallas, Texas. She has a lot of experience, and she will critique this survey that the defense did. And basically, she points out flaws on how it's designed or how it's executed. And I also perused her website. She's quite expensive, Vinny. So her survey rebuttal reports typically range from $15,000 all the way up to $30,000 that the prosecution would have to spend to hire her to rebut the defense's survey.
You know, it's interesting. They should have called me. I got a guy I'll do it for half price, but he's up in Jersey. Anyway, Ted.
I'll do it for you right now.
Exactly.
Move the trial.
Move the
Save
trial.
Everybody the money, because here's what's going to happen. Yeah, she's going to pick apart this ridiculous survey that wasn't very good in the first place. Yes, it is going to be compelling, so they're going to start voir dire, and guess what? Everybody thinks they're guilty. Yes.
Well, you know what's interesting, Ted? Are you telling me in all those counties you can't find 12 people? And
Not
those 12 people.
I'm saying in those three little dinky Mormon counties.
You don't think you can find 12 people in those three counties? Because let me tell you, I think the defense is off base here. You're better off being in those three counties, because once you get rid of all those people that made up their mind, think about who you have left over. Those would be good defense jurors. This is where I think criminal defense attorneys get it wrong almost every time. All they want to do is move the case, move the case, move the case, when, you know what, when you do a good voir dire and you eliminate the people who formed an opinion, think about who you're left with. You know, you're left with those 12 people who, down in Pinellas County, Florida, who, you know, Ted, what I'm talking about, who somehow, some way told that mother that go have a nice day. That's the problem that you run into. And Boise, Ted, describe for us, isn't Boise like dangerously close to like Portland, Oregon, California?
Yes, yes.
That's the
right.
problem there.
Problem for you, but for the defense, that's where they need to go, I think, because they have a pool there that you could imagine there would be some people that haven't kept up with this case. That's not the case over in Eastern Idaho.
Yeah, but I'll tell you what's really happening, Ted. They're just trying to keep the case out of the hands of any Mormons, which is wrong, which I think is wrong. But no one's going to say that on the record. I will, but no one else is going to say that. Chanley Painter, great job. Ted Rollins, it's always great to see you. You look good. Doesn't Ted look good tonight, Chanley?
Looks great. I love it.
It's really good tonight. I don't know what it is. All right. Thanks so much, folks.